Hello everyone, myself Madhuri, Associate Professor, Department of Law, Padmavati University, Tirupati. Today we'll have another topic, that is performance of contracts. The performance of contract is the carrying out of promise made by the parties, and it can be done in several ways, including through actions or inaction. For a contract to be valid, both the parties must perform their obligations as laid down in the contract as agreed. If one party fails to do so, it can lead to disputes and litigation. And we have three types of performances we have. It could occur into your contract: actual, substantial, and perfect. Actual performances, if you want to see, this is one where both the parties have fulfilled their obligations as set out in the contracts. It usually occurs when goods or services are delivered in the following terms agreed. Substantial performances, which comes under, is one where some of the obligations under the contract have to be met. For example, if a contractor completes most of the works but does not finish it, this would be considered as a substantial contract. It is up in the courts to decide whether or not to sufficient for one party to receive payment. Breach of contract will comes under another category. A performance by any of the parties is not been done, or substantial performance is not satisfactory. And coming to the joint promises, we can say section 43 gives you a picture. Any one of the joint promiser may be compelled in the performances. When two or more persons make a joint promise, the promisee may, it is in the absence of express agreement to the contract, compel of anyone. Each promiser may compel contribution. Each of two or more joint promises may compel every other joint promiser to contribute equally with himself to the performance of a particular promise. Sharing of loss by default in contribution also comes under this. If any of the following from a joint properties make default in such contribution, the remaining joint promises must bear the loss arising from the such default in equal shares. Reciprocal promises which also comes under another angle. The parties might agree upon the order to which the particular promise have been performed. In that case, the order mentioned in the contract should be followed. However, the contract does not specify such order. The order of a performance reciprocal promises is determined as based on nature of transactions. And tender is another offer. It is something which has been invites and to invite acceptance. And sometimes we can say large contracts, the list will be prepared and tabulated. The name of the contracts who have been tendered in the displayed. In front of each name, it indicates the total prices offered and an observations made by the contractor or a particular condition that the contractor wishes to regulate its execution of a work. The offer made in an offer to meet conditions or an obligations together, current capacity of an immediate execution. So, if they were not refusal of a cooperation, the party to which the offer has been made, conditions and obligation would be met immediately. A tender is also in another offer. It is something invited, communicate to notify acceptance. In general terms, we can say it must be unconditional. It must be done in the right place, and it must also conform to the terms and of conditions or an obligations. It must be done at the right time, and it must be in a proper way. And we have to fulfill a particular obligation. Reasonable opportunity for inspection should be there and made on the right persons, and it must be for the total amount. Tender also can be concerned upon an open contract whom the particular obligations has to be done, and we have to quote that one, and fulfilling contractual obligations of the tender. And even all the countries, money is being called legal tenders, and all countries of the national bank of countries promises to pay bearer indicated some of the money should be or can be on a demand. All tenders are legally binding on both the parties, and it should come under large tenders, maybe in a sub tenders by the contract, or may consist of more of the contracts, easier and the faster execution of the tender. Finally, the performance of the contract is essential effectiveness. By ensuring that your contract is effectively performing, you can avoid any legal issues and ensure that both the parties are satisfied with the arrangements. If you are looking for more information on a contracts, need help in drafting of one yourself, an experienced legal professional can be consulted. And at the same time, they can also help ensure that contract is clear, concise, and effective. Thank you.